All right, good evening. Make sure we get close to the microphone here. Welcome back. We are going to continue the next segment of our agenda with our pre-termination hearing for Katie Medart. Please bear with me as I will read through the announcements that were read at our first hearing. This is a formal proceeding of the Grants Pass School District Board and an opportunity for the board to consider matters before it. Although this meeting is open to the public, no public comments will be allowed at the hearing. The board is hearing this matter based on solely the records and reports before it, which until this hearing have not been made part of the public record. It is expected that everyone in attendance will act civilly and avoid disruptive behavior. No protesting or signs will be allowed in the building. If any person disrupts the proceedings, they will be asked to leave. If the meeting becomes disorderly, we will excuse the public from in-person attendance. In such event, the meeting will continue to be available to the public virtually via Zoom. The Oregon Legislature has established the process and the standard for dismissal of probationary teachers and administrators. ORS 342.835 parenthesis 1, parenthesis provides the district school board may discharge or remove any probationary teacher during a probationary period for any cause considered in good faith sufficient by the board. The probationary teacher shall be given a written copy of the reasons for the dismissal, and upon request shall be provided a hearing thereon by the board, at which time the probationary teacher shall have the opportunity to be heard either in person or by a representative of the teacher's choice. The hearing tonight is a pre-termination hearing to provide the employee with due process, including hearing the reasons for dismissal and providing the employee the right to respond and be heard before the board determines whether the employee should be terminated. The employee has requested an open hearing. Therefore, this hearing is being held in public session. This is an opportunity for the public to hear the proceedings. It is not an opportunity for the public to participate in the hearing because the board is to consider the matter based on the records, reports, and arguments provided to them and not based on public opinion or other factors. Public comments received by the district related to this matter will be provided to the board after this matter has been heard and determined. The public may provide comments to the district to be forwarded to the board or directly to the elected board members through official mail or email addresses. The board appreciates public input on matters of concern and will review public comments at an appropriate time. The board has been provided a report and with materials collected by Bill Landis from Pacific Consulting and Investigations, an independent investigator who reviewed complaints against the employee and prepared a written report. The employee and attorney for the employee were provided with the opportunity to provide the board with additional written materials or documents to review as part of these proceedings. The procedure for tonight will be as follows. The district administration will brief the board as to the reasons for the recommendation of dismissal, and district administration will be provided 10 minutes to set forth the reasons for dismissal. The employee or her attorney will be provided with 30 minutes to respond to administration's recommendations for dismissal. Administration shall then have 10 minutes to reply to the employee's response, and the board may then ask questions of the employee or administration. Upon conclusion of any board questioning, the hearing will then be closed, and after a motion is made and seconded, the board members may deliberate and then the vote will be taken, and that will conclude the board action on this agenda item. Are there any questions from the members of the board? At this time, the district's attorney, Nancy Hungerford, will review the reasons for termination as set forth in the superintendent's recommendation to the board. Nancy.
Okay. I'm going to try to make sure that everybody can hear me this time. I understand last time I wasn't being received, and I was having a hard time hearing you too, so we'll work on that. Members of the board, I know that you have spent an equivalent amount of time reviewing the investigation materials into the independent investigator investigation of Ms. Medart. And the policies that we're going to be talking about are much the same, and those portions of the policy. Once again, the list of, and I think you have a copy now of the June 18th, 2021 letter from the superintendent indicating the bases upon which the violations are been found and the recommendation has been made. I want to clarify a little bit about the process. In this case, it's a little bit different. Ms. Medart is a member of the teachers' bargaining unit. She's covered by a collective bargaining agreement. There is a complaint procedure in that collective bargaining agreement. In this particular case, however, very shortly after the initial conversation between the superintendent and the two employees, Ms. Medart being one of them, those employees brought some complaints against the superintendent, the principal, and the HR director. As a consequence, those folks were no longer able to serve as hearings officers or as decision makers in that complaint process. The complaint process moves from principal, your immediate supervisor, and then it may move in some cases to the human resources director, superintendent, final. Because those folks were deemed not to be impartial, or they were requested by the association to not be involved in the complaint procedure, then the district did move immediately to have an independent investigator. There had been an attempt to investigate before that time with the building principal and some of the other administrators, but upon hearing of that claim of lack of impartiality, the district took the only step it had possible, which was to use an independent outside investigator. So that's why this process, and I think that similarly affected the situation with the other employee, and maybe it wasn't made clear in that hearing that that's why we ended up going with the independent investigator. So let me turn to the findings of that investigator as we look at how those constitute violations of the policies. And I'm looking here now at the last few pages of this 100-page or so report that the investigator produced, which you had an opportunity to review over the last couple of weeks. I want to particularly focus on a few factual findings that the investigator made. And one, this is on the first page of the findings section, that Ms. Medart, by her own admission, used District 7 computers, email, school property, and Google Docs to share or communicate regarding the I Resolve campaign with colleagues, staff, and persons inside and outside of the district. This was supported by exhibits provided regarding email use, and those appeared as an exhibit attached to the materials you reviewed. So there was no contest in the mind of the independent investigator. There was acknowledgement by Ms. Medart that she had made that use of computers, email, school property, and Google Docs, and that is then therefore directly in violation of the policies that we cited to you in the last case. The second issue that he deals with in terms of the evidence that the investigator found was that timestamps on emails shown in Exhibit 4, as well as Ms. Medhart's admission that she used time during her workday to communicate regarding I Resolve, both in emails and face-to-face communication with other District 7 staff and face-to-face communications. She also admitted to using District 7 computers to work on I Resolve, and goes on to state that the amount of time is not an issue here because the policy states, nor will any employee use any time during the working day for campaign purposes. And for the whole policy, what we're looking at here is an admission and evidence that the investigator found convincing that that policy was violated because of the use of district property and equipment and district time. The next portion of the policy deals with, and we're still dealing with GVG, and we're still dealing with a policy that was in effect in March of 2021, at the time these events occurred, was that he found sustained the charge that Ms. Medart had on controversial issues. She had failed to do what the policy requires, which is that she must designate the viewpoints that represent on the issues are personal viewpoints and are not to be interpreted as the district's official viewpoint. Again, that's on controversial issues. I don't know that anyone is really in doubt that this is a controversial issue. So it's not just limited to campaigning. It is focused on any controversial issues. And he cites what was stated, and you probably have all heard it if you've reviewed that videotape. My name is Katie. My experience with youth, as I've been teaching for the last 10 years, I am currently teaching at a middle school in Southern Oregon. And while Ms. Medart has said, well, I didn't mention Grants Pass, once again, once the vice principal was located, it became pretty obvious where Ms. Medart was teaching. It was not something where there was any disclaimer. Ms. Medart admitted that to the investigator, that they had no disclaimer that identified their opinions as being personal as opposed to being the school district's. And the investigator also finds that individuals who were disturbed and concerned understood that they believed it was the district's position in some cases. So they failed to do what is required of them, and Ms. Medart as well, affirmatively to say, this is my own opinion, this is not the opinion of the school district that I work for. They did not do that. Later there was a disclaimer, but that was at least a week after this video was released. And the conclusion of the investigator is that Ms. Medart doesn't introduce herself as a private citizen, but rather as a Southern Oregon middle school teacher, giving her first name. While she did not say Grants Pass School District 7, she at no time in the video states that the views expressed are those of her own. So that is a finding of your investigator. Also, it noted that the subsequent media coverage, that there were no statements by Ms. Medart or Ms. Zamo that there was, the I Resolve campaign was not affiliated with the district. So there was that particular accusation that was found to be valid. And then finally, there is this policy that talks about staff members while on duty and off duty will utilize social media websites, public websites, and blogs in a professional manner by not posting confidential information about students, staff, or district business. In Ms. Medhart's case, in that video, she shares an account of a matter that occurred, and she timed it, she dated it to the previous year. She's a second-year probationary teacher, so that previous year was her first year she was working in this district. And she disclosed details about a female student who was exploring gender identity and requested to identify as a male. Staff members knew who she was talking about. Individuals could very well have connected, but even if they couldn't, the idea that they have a teacher who's talking about a student and about a student's difficulties or concerns, family issues and so forth, regarding gender identity, that leads people to distrust staff and their ability to be confidential. That's what's at stake here. And that is a very grievous wrong in the minds of the district, that by including that information, Ms. Medart made it possible not just for some people to identify that individual student, but for a lot of people to say to themselves, I don't really trust that district staff are going to be confidential with my information. And we know that sometimes people make conclusions based upon one example, but at the very least they would conclude that Ms. Medart wasn't to be trusted with that information. That's a long-term consequence. As I stated earlier, probation means a trial period. It's a testing period. The collective bargaining agreement you have with teachers specifically excludes termination of a probationary teacher from any grievance procedure under just cause. So there's been a recognition on the part of the association as well as the district that it is a trial period, and it is a time when you can exercise a decision-making to remove an individual or not continue that individual as a staff member in your district. And that is what the superintendent is recommending that you do at this time, is that you terminate her employment. Thank you.
Thank you, Nancy. All right, we'll have 30 minutes now, up to 30 minutes for Ms. Medart and her attorney to present.
Thank you for this time to be heard. Can you hear me? Okay. To start, just on the note that was left off, I would like to, before reading my statement, I was in good standing before we posted our video. My contract has actually already been renewed for last year. So to say it's completely probationary, I was approved by the board and signed my contract to return next year. So thank you for the opportunity to respond to Mr. Kolb's recommendation to terminate my employment for expressing my ideas and beliefs related to iResolve. I would like to share a little bit about myself as you consider the issues before you. I must say, I believe every student belongs. I care for all of my students, and I believe it is an honor to teach them. I have been in education for 14 years. I have taught high school science, anatomy and physiology, chemistry and biology at a community college, and in the past 2 years, I taught middle school science and health. I must say that I also learn from students, colleagues, and staff from the frank and honest exchange and expression of ideas. The free exchange of ideas is a hallmark of a functioning and healthy educational system. Thus, I hope that you as my employer stand with the constitutional rights of citizens to offer public opinion regarding pending legislation and not a predetermined point of view as determined by my employer. I'd like to turn to reasons Superintendent Kolb has provided for recommending my dismissal to the board. Number one, Mr. Kolb claims violation of board policy GBG in 2 ways. These are quotes from that. Use district facilities, equipment, and supplies to conduct personal business of a political nature. Use time during District 7 working day for political campaign purposes. Mr. Landis's finding of fact report indicates that computer equipment and work hours were used in limited capacity. On part 1, page 3 and 4, if you take a look, there are 7 emails that I have listed as the evidence for Mr. Landis' report. You'll see timestamps are in the evening, and most of them occur on spring break. iResolve resolutions, so for work related to iResolve. iResolve resolutions and video were crafted and made away from school on my own time, using personal resources that did not belong to the district and without interfering with my job duties. Any use of school time or resources was de minimis, and certainly less than time and school district resources used, for example, by other staff members for the March Madness bracket betting pool, a discussion by the administration and staff of weekend or holiday activities, or even time devoted by numerous staff members to discussion of the 2020 election. I use district resources in an acceptable way that all other staff use it, and not for political campaigning. The ORS is what gives authority and definition to Board Policy GBG. Policy GBG utilizes the ORS phrase political campaigning. However, ORS 260.432 clearly defines political campaigning, which makes it absolutely apparent that the alleged activities that Rachel and I engaged in are definitely not political campaigning. And therefore, I did not violate policy GBG at any level. The Administrative Rule Manual for ORS 260.432, and in fact the ORS itself, addresses the only 4 times in which the term political campaigning applies, each of which are clearly defined by ORS 260.005. These are 1, for initiatives, referendum, recall petition efforts as soon as it's filed with election filing officer. Number 2, ballot measures refer to the ballot, political candidates, political action committees. We are none of these. Voicing opinions regarding pending or proposed legislation is not political campaigning. In fact, ORS 260.432 subsection 2 specifically states this section does not restrict the right of a public employee to express personal political views. I did not violate board policy GBG, and my expression of ideas is constitutionally protected from retaliation by the government, including the school district. Finally, related to Kolb's claim violation of board policy GBG, when posting the I Resolve movement video, and this is a quote from Mr. Kolb, I failed to identify that the political viewpoints were my personal viewpoints and not representative of the district. The fact is, District 7 is never mentioned. There is no need to state that the views are not those of the District 7 when the district is never mentioned in our video. Furthermore, we share that we are middle school educators in Southern Oregon. Depending on how you define Southern Oregon, that could include at least 14 middle schools, not including private or charter schools. We offered our personal perspectives and proposed actions with no belief that we were speaking as representatives of the district or anyone else. Mr. Kolb's claim violation of board policy IIBGR-AR. This is a quote. Use the district network for transmission of the related materials and information of these political campaigning efforts. Policy actually states this. This is letter F to clarify what that is not correctly stating. Transmission of any materials regarding political campaigns is prohibited. As explained earlier, we did not engage in political campaign, thus this was not violated. The third alleged allegation against me is a violation of board policy GCAB. Mr. Kolb claims, your personal use of social media, and this is a quote, very much created a substantial disruption to the school environment. The actual policy GCAB reads, staff members, while on and off duty, will treat fellow employees, students, and the public with respect while posting on social media websites, etc., in order to prevent substantial disruption to school. If a person respectfully disagrees with another person, they cannot be held responsible for the offense and reaction of the person addressed. We teach our students all the time, you cannot control how others respond, but you can control how you respond. Mr. Landis's finding of facts on part 1, page 131 of your report, does not identify if our video was respectful in and of itself, but claims that we are responsible for the reactions of others. We were deemed a direct conflict of district values by Mr. Kolb. That exhibit is in part 4, exhibit 5, and further falsely labeled anti-trans movement. This was an email sent in Canvas by a North Middle School staff to North Middle School students on April 20th, 2021, using district property during school hours. We were labeled disrespectful and deemed a disruption not for our actual behavior and words, but because of how others responded to them. I ask you to hear these positive testimonials as the district's findings and evidence that stand in contrast to Mr. Landis's report, which only provides negative comments to support the claim of a substantial disruption. After posting I Resolve, 7th grade science student, I'm honored to learn from you. Parent in Josephine County, saw your video, proud of you both for standing up for what is right. 7th grade science student, to Mrs. Medart, mind-blowing, easy, daring, amazing, right, talented. District 7 staff, I thought your video was a professional way of presenting an option of how we deal with this very divisive issue and how the people that do not agree with your option are acting is shameful. 7th grade science student, Medart, she has helped me with anything I needed help with, and she's really nice and makes science fun. Thank you, Mrs. Medart, for always being so enlightened and happy, and I thank you for standing up for what you believe in, even though others look down on you for it. It takes a lot of courage to stand up and speak your mind, knowing that others will hate you and seek to bring you harm from it. Finally, Mr. Kolb claims violation of board policy GCAB, stating, and I quote Mr. Kolb, I posted confidential student information in my I Resolve movement video. While not explicitly using the student's name, the specific details of the scenario I described was determined to have occurred to the extent that many individuals were able to discern who you were referencing. Mrs. Hungerford clarified, staff. Mr. Kolb's assertion that I released confidential information about a student is completely unsupported and false. The scenario I described was a hypothetical that pulled from situations that are commonly seen. Some observed, some read, some heard. Maybe I wasn't artful enough in communicating that, but I did not release any confidential information that would violate the meaning of the law. I said nothing that would make clear I was talking about any particular student. If aspects of the description happen to fit one or more students in our district, that's purely coincidental. I provided a common scenario to tell a story, to provide a grounding for the expression of our ideas, and for concerned citizens to relate to. Mr. Kolb refused to hear this and took one part of what I said in the video instead of the time frame and specifics of the example so that he could make a false claim that I released confidential information. Using what I stated in our iResolve video in its entirety proves I did not release confidential student information because it does not match any one student situation. I submit to the board that based on my evidence given, the law, and my constitutionally protected expression of ideas, this board should not affirm the recommendation to terminate my employment. Furthermore, I ask the board to please consider the words of a District 7 staff member in response to Superintendent Kolb's statement to the press and email to the community, in which Superintendent Kolb stated that the iResolve movement was in direct opposition to the values of District 7. I would ask you to reflect on these words and determine what overall message you want to give to our community about the purpose and goals of education. To quote this staff member, "After reading through the verbiage of the iResolve policy proposal, I was left wondering which specific words, phrases, sentences were in direct conflict with the values of the Grants Pass School District 7. It also caused me to reflect on the word 'we' used in the email. We do not support or endorse this message. Who is the we in District 7? This is a good question. Who is the we here? Rachel and I have always acted as part of and in the interest of all communities, and the expression of our ideas were in service to all communities. And given the response to the expression of our ideas by colleagues, staff, and the community, we understand that while some may disagree with some part of our ideas, they overwhelmingly believe we should not be dismissed for expressing them. We aim to propose reasonable, loving, and tolerant education policies that respect everyone's rights. No educator should be punished for sharing ideas, nor for desiring to have a tolerant conversation around them. I ask you to affirm that teachers in the district can express ideas in a reasonable and thoughtful manner without facing banishment, exile, and retaliation for having done so. I urge you to vote against Superintendent Kolb's recommendation for termination. Thank you for your time. I understand my attorney will address you briefly on my behalf.
Thank you, Katie. My name is Ralph Weiser. I'm a lifelong Oregonian. I've been representing teachers since 1983. I'm here pinch hitting for Ray Hackey, who has filed 2 lawsuits alleging violations of the First Amendment, the Oregon Constitution, and various other federal and state laws against the board. I want to say at the outset that your board does not have the authority, as applied apparently by Ms. Hungerford, that you can enact lawfully policies that violate the First Amendment or apply policies that violate the First Amendment, and you've done both. I also want to correct a misimpression about the case out of the Sixth Circuit that Ms. Hungerford talked about. In that case, the school was going to dismiss the professor for refusing to address a trans student by the preferred pronoun. The United States Supreme Court did not hear cert. The Sixth Circuit held that the school's action violated his First Amendment rights. That's what happened. Now, I say in terms of this independent investigation, that this independent investigation was, in my opinion, not complete, flawed, and that you should not give up your rights to make your own decisions as to whether or not board policy was violated. and I would endorse the analysis that Mr. Richardson on your board did in Ms. Damiano's hearing, which was a correct analysis. There were no violations of your policies. Pursuant to your attorney's directive, I provided the district written materials relevant to Ms. Medart's appeal by the district-imposed deadline of July 9 at noon. I assume that these materials have been provided to you for consideration. They include the lawsuit filed against the district by Ryan Clark and the lawsuit filed against the district by Katie Medart and Rachel Damiano. These lawsuits are based on several violations of First Amendment of Mr. Clark's and Ms. Medart and Ms. Damiano's rights to free speech. The lawsuits are not based on competing views of the speech involved, but on well-established rights to express competing views, which go to the heart of the First Amendment, which on the one hand champions and prizes free speech, and on the other condemns as here the government's attempts to an actual silencing of free speech. You need to look no further than the United States Supreme Court's recent opinions regarding free speech protections as provided in Manahoy Area School District v. Levy, issued just 3 weeks ago. By reference specifically to the nation's public schools, including the Grants Pass School District number 7, the court stated that, quote, America's public schools are the nurseries of democracy, close quote. And further, that public schools have the duty to teach students that freedom of speech, even unpopular speech, is essential to our form of self-government. By contrast, your superintendent has proven that this school district is not a nursery of democracy and is asking you to join in his condemnation of free speech by dismissing Ms. Medart. Your superintendent is teaching students that speech with which they may disagree must be silenced and suppressed. The Supreme Court has stated time and again that the First Amendment protects speech even that people don't like, including pornography, profanity, and yes, religious speech. In fact, in Snyder, the court stated that the First Amendment protects speech concerning issues of public morality, including sexuality, and specifically prohibits government agencies from showing hostility towards Christian viewpoints. Returning to the point that Ms. Medart's speech away from school and in school was protected by the First Amendment, in Tinker v. Des Moines Independent School District, the court stated that teachers don't check their rights to free speech when they enter the schoolhouse gate. In Pickering v. Board of Education, the court found that a school district's dismissal of a teacher for criticizing the policies of the school district about a matter of public concern violated the First Amendment. In a recent decision of the Ninth Circuit issued this year, Moser v. Las Vegas Metropolitan Police Department, a police officer engaged in incendiary speech that had a tendency to reflect badly on the police department, in response to which the department removed him from the SWAT team. In finding that the department violated Moser's First Amendment rights, the Ninth Circuit stated, quote, vigilance is necessary to ensure that public employers do not use authority over employees to silence discourse, not because it hampers public functions, but simply because superiors disagree with the content of employee speech. Here, Katie's speech did not hamper the district's ability to function. Rather, she tried to suggest something that would help the district function better by considering the rights of teachers, of parents, and others, while still respecting the rights of LGBTQ students. Under the superintendent, the district has a history of retaliating against those who express ideas with which the district disagrees, as set forth in the lawsuits pending against the district. The district has repeatedly engaged in viewpoint discrimination in violation of First Amendment and continues to do so. I'd like to turn briefly to the reasons asserted by the district for dismissing Katie, bearing in mind the limited time I have to address you. At the outset, let me tell you briefly why I think, and the credible evidence shows, that the reasons asserted by the superintendent through his counsel are false and simply a pretext for the real reasons the district has recommended to you that Ms. Medart be dismissed, her free expression of ideas and beliefs. It's because before I represented Katie Medart, I represented Ryan Clark. Prior to the lawsuit filed on Mr. Clark's behalf, Mr. Clark got into the trouble with the district because he made statements away from school, not on school property, on his own time, based on his religious beliefs and free expression of his ideas, and the district investigated and gave him many directives, many of which concerned what Ryan could and couldn't do or say when he was away from school, not on school property, not on his own time. With all respect, the Ryan Clark events are reflective of the district's wrong-headed, illegal, and unlawful conception of its authority to regulate and punish free speech under the First Amendment. After Mr. Clark filed his lawsuit, the district proposed updated directives that sought to silence his speech and right to free association even when he was not at school or on school time, and would have extended to his activities in his church and fellowship or in the greater Grants Pass community outside of school. The district's directives Mr. Clark proposed on the very same day that Ms. Medart and Ms. Damiano filed their lawsuit in early June show an utter disregard and violation of Mr. Clark's rights under the First Amendment. And this is also during the same time that the district was responding to this free expression of ideas by Ms. Medart and Ms. Damiano. And at the same time, they responded to the district's secret policy regarding LGBTQ. And at the same time, the district placed them on administrative leave. And at the same time, Superintendent Kolb issued his memo to the community that Katie and Rachel had violated the district's policies by the expression of their ideas, the utterance of their speech. This was before the district needed to create a plausible, lawful excuse for placing Katie Medart and Ms. Damiano on administrative leave, and now seeking to dismiss them. In support of creating a plausible reason for placing them on administrative leave, the district hired an investigator and now seeking to dismiss them, the district hired an investigator to conduct an investigation. As regards the investigation of Superintendent Kolb and Administrators Blanchard and Cantola, which was performed only recently in June, after Ms. Medart and Ms. Damiano filed their lawsuit, and after which the facts of First Amendment life could be explained to the superintendent, did the district arrange to have the superintendent interviewed. And even after that, and assuming preparation for the interview so that the superintendent could utter statements that provided the district a defense in the lawsuit, the superintendent told the investigator three things that are of significance here. First, that Ms. Medart and Ms. Damiano, speaking in their video on their own time away from school, became, as Superintendent Kolb stated, quote, intertwined with the district because of them representing themselves as educators in the district, close quote. First, they did not state that they taught at or were speaking for the district. Second, as far back as Aristotle's rhetoric, a listener wants to know if the teacher should be believed. Are they credible? Do they have knowledge or experience that informs the ideas they express? And that is the reason that Ms. Medart and Ms. Damiano identified themselves as educators. Let's face it, if I were not a lawyer, why would you credit my opinions about the purpose of, basis for, and reach of the First Amendment? Beyond the issue of credibility is that Katie and Rachel did not wear any clothing in their I Resolve video that would identify them as employees of the district, thereby avoiding any indicia that their speech bore the district's imprint, and the video did not criticize the district in any way. On that subject, I'm not aware that there is any affirmative obligation, that they had any obligation to say explicitly that I do not represent the school district, when in fact they said nothing that indicated they represented the school district. That is simply an engraftment on and an argument to serve up to you to affirm the superintendent's recommendation. Second, Superintendent Kolb said that teachers often express their personal opinions and beliefs at school. This is what he told the investigator, on school time, and they are not punished for doing so. nor are they accused of engaging in disruption of the school's educational mission. Here, Katie's speech did not affect learning-related activities. Third, Superintendent Kolb encouraged Ms. Medart and Ms. Damiano to take down the iResolve website and petition, even though there was no lawful basis for seeking to have them do that under the First Amendment, and that request by itself is an affront to it. Now, the superintendent wanted Katie and Rachel to shut up, to stop talking, to become mute and mum, because he perceived that their expression of their ideas had caused complaints, criticism, and controversy. But under the First Amendment, that is not a valid reason for silencing employee speech concerning ideas about governmental policy with respect to a matter of public concern or controversy, as here. That is what is meant by there not being any, quote, heckler's veto of speech protected by the First Amendment, as the Supreme Court explained again in the Manahoy case issued just 3 weeks ago. So the superintendent, or those representing him, needed a plausible, different reason. That despite others being allowed to express their beliefs or opinions on the job during school time, as the superintendent admitted, that Medart and Damiano used school time and email to communicate about their ideas in a way that violated school policies, even though the time they used was minimal and very much in line with others who used school time and email to conduct their personal business or to express their personal opinions or beliefs. This kind of viewpoint discrimination violates the First Amendment. With all respect, the difference between the superintendent's conception of the First Amendment is that he appears to view it as an artifact from an old document that bespeaks a concept that he simply bends to his will and needs as the occasion presents itself or as he thinks requires. He simply creates a policy or an excuse to favor one idea or kind of speech over another. If you don't believe me, simply read the Clark and Medart and Damiano lawsuits. They illustrate these points beyond dispute and succinctly. But that is not what the First Amendment is, or how the courts view it, or how those who love, respect, and understand the First Amendment view it. They view it as a living, breathing, corporeal thing that is alive, robust, and healthy. But as in this case, can be injured and violated, so it lay bleeding in the ditch until others come to its aid and breathe life back into it. You should not dismiss Katie Medart. To do so will compound further the deprivation of her First Amendment rights and expose you to further liability for your actions. You should not dismiss Katie Medart because it is not you who will pay, most likely, but the taxpayers who fund your $100 million school district. And you should not dismiss Katie Medart because it will teach students that the school district does not believe in democracy, free speech, or robust debate. That is the antithesis of the First Amendment. Now, the decision is up to you. The public and taxpayers of your district are watching, and the courts will scrutinize your decision. And I would ask you, on my client's behalf, that you deny the motion that will come before you to dismiss Ms. Medart. Thank you.
Thank you. We will now hear from Nancy Hungerford's response, and you will have 10 minutes. Nancy.
Thank you. Board members, I would advise that you reflect about the kind of intimidation tactics that you have just heard, threatening you with the idea that there's
Nancy, would you speak into the microphone? I don't know that everybody's here. Thank you.
threatening that there's going to be court cases, action, etc. It is very easy to file complaints against school boards. It is very easy to file complaints charging violation of First Amendment rights. Whether those prove out Well, I would tell you that most of them don't ever go to court. I would also tell you that you have liability insurance coverage, so the idea that the taxpayers are going to pay, you maintain that coverage regardless of whether you have lawsuits or not. But I feel that that's a threat that's being lobbed here that is totally groundless. Secondly, let's talk about some of the court cases that have been cited here. First of all, the Supreme Court did not deny cert on the case that Mr. Weiser is referring to. They denied cert on the Gavin Grimm case, which was a case where the lower court upheld the rights of Mr. Grimm, who is a trans student and who insisted that he be called by the name that he preferred. That court ruled for him. The Supreme Court's refusal to accept that, refusal to review that simply leaves that lower decision standing. So obviously we're not talking about the same court decision that I was talking about. In addition to that, I would ask you to think about whether there's any correspondence between cases where we're dealing with students' rights to free speech, going back to the Tinker case, the Black Armband case during the Vietnam War era. But this Manahort case that just came down from the Supreme Court has to do with a student who, in her own free time, made some derogatory comments. Well, not even derogatory comments. She made comments using the F word, and her sponsors took her off the cheer squad. I don't think we're talking in the same league here. We're not talking about employee speech. That's a case that had to do with student speech. The standards are quite different. In addition to that, the fact situation is very different. So there will be cases where the courts will find First Amendment rights have been violated. We don't believe that the ones that have been filed here will have that finding. No one can predict that, certainly not Mr. Weiser. In addition to that, the idea that the board cannot have policies that violate the First Amendment. When teachers and administrators, when teachers are working in the classroom, they do not enjoy First Amendment rights. They are working for the state. They are working for the school district, and I could cite a number of court cases in which that has been found. So they do not enjoy First Amendment rights when they are on the job, when they are teaching. They have First Amendment rights in their out of school, away from the classroom, ordinary day. So I think that to extend the analogy, and I'm assuming that Mr. Weiser has Mr. Clark's permission to use his personal situation, and therefore I would share with you the fact that the school district, because he never engaged in any conduct that was in violation of directives that related to his on-the-job use of speech, he never engaged in anything that violated any of the directives. Those directives were removed at the end of the year, and he is only under the same conditions that all of the other teachers are. I also would point out to you that the contention here is that there was no policy violations. I'd like to pass out a copy of the policy that we're dealing with here in part. This is only one of the policies that I mentioned to you. And assuming Mr. Weiser has a copy of that, and I would point to the portions of this that are at issue here. There are two paragraphs in this policy that don't relate specifically to campaigning. One of the ones we've talked about is the third paragraph, on controversial issues, on all controversial issues. Employees must designate that the viewpoints they represent on the issues are personal viewpoints and are not to be interpreted as the district's official viewpoint. That is an affirmative act required of the employee. It isn't something that someone has to find out or ask them a question about or whatever. It's an affirmative act that they must undertake. so that their position on controversial issues is not assumed to be that of the district. But in this case, where the employee identifies herself in this video as being an employee of a middle school in Southern Oregon, I'm sorry, it didn't take very long for people to figure out where she was working, and it was North Middle School here in your district. She had an affirmative obligation under this policy, and she didn't do it. The other part is in the second paragraph, the second sentence there, where it says, such discussion and persuasion will not be carried on during the performance of district duties. And then there's an exception if you're like a social studies teacher and you're going to have a unit on the election, and in that case, you're required to provide both sides. And so obviously that doesn't fit, but certainly there was not a discussion of the alternative point of view in this video. But such discussion and persuasion, so in those circumstances, will not be carried on during the performance of district duties. And Ms. Medart violated that. So we believe that those policy violations do stand. There are, I think, a number of other things that I would respond to, but based upon the time here, I want to take particular issue with the statement that Katie's speech did not affect education in this district. And I am aghast at that statement. When we have a student in your school district who knows that the teacher that she chose to communicate with has had that revealed. There are people in this district who know who that is, who have identified who that is. But even if that's not the case, even if you don't, what about those other students in this district who are struggling with gender identity, who are concerned about having someone to talk to? What is the impact of on those folks when they know that a teacher in this district disclosed this kind of information? And it's not just to a couple of people at the school. It's not just even in this community. It's the whole world. This video has gone viral. It's being, reviewed in all sorts of different places. Think about that student, but also think about those other students in your district. And I would tell you that there is a very strong basis for dismissing this teacher for that reason alone. She did not observe confidences. She first tried to say, well, initially she said that it was based upon a real example. She told the investigator that. Then later she came back and said, oh, well, that was just a hypothetical situation. But we know that it was a real example, a real student that she was involved with. There are a number of different bases here for dismissal, but certainly there is enough for you to dismiss a probationary teacher. Ms. Medart has said that she was renewed by this board. By law, that action had to happen by March 15th of this year. This information was not available to the board when they renewed her contract. But the fact that she was renewed under Oregon's law does not mean she has a job for next year. She can be dismissed at any time for any cause deemed in good faith sufficient by the school board. And I believe that you have definitely seen cause to dismiss her. Thank you.
Thank you. At this point in time, we will open it up to questions from the board for either Ms. Medart or her attorney or...
Mr. Nelson.
Yes.
Sorry, at the end, when Ms. Hungerford claimed, I went to my pre-termination hearing. So I was given one.
Would you speak into the mic, please? Thank you.
When Ms. Hungerford claimed that I did not attend my pre-termination hearing, I did. So I went to a pre-termination hearing prior to this one with Ms. Ely and
Excuse me,
Mr.
I did
Cole.
not contend that about you, Katie. I contended that that was true about the other individual here. And so I never made the contention that you didn't attend your pre-termination hearing. What I'm saying now is that the decision of the board to renew your contract occurred in March. And you identified that it's already happened, this board has renewed your contract. Yes, they did in March. But I'm not making any contention that you did not attend your pre-termination hearing, not at all.
Okay.
Okay, thank you. At this point in time in the hearing, we will open it up for questions from the board members.
My first question would be to clarify for me, there was a complaint against Superintendent Kolb. Was that from Katie only, or was that from Katie and Rachel?
Okay. Go ahead, Sherry, you can answer that question.
That was only from Katie? Okay, that's what I did give from the record, so that was different between the two. You have one? This would be for Bill Ransom. We received a communication that we were to ignore the court cases in our deliberations for deciding in this termination.
As far as, well, I think, hold on. Thank you. The board was suggested that the decision should be made today based on the record before it and not risk or future potential liability to the district. That would be, that's not part of what the record before you for the decision would be.
So the information in the court case or cases wouldn't be part of the record that we should be considering?
You're talking about the allegations in the lawsuit?
Yes.
Those are allegations. If those are just allegations. If you don't have facts, then that would be what that is what they are. They're allegations in the lawsuit.
Okay.
Just for the record, I submitted those lawsuits to be considered in this hearing,
And they have been.
and they are relevant to the issues before this board.
Yeah, and they have been.
Well, so
Also,
that's
to
kind of what I'm
clarify-
trying to determine. They submitted those to be part of our deliberations, but it was my understanding from your communication that we were not to use those in our consideration for this hearing. So I'm a little confused.
You can do with them whatever you think you need to do as far as the value, the risk of liability to the district is not what we're here for today, to evaluate that. And that is not something that we believe should be considered as part of your decision. Your decision should be made on the record. And the records, and it's correct, they did submit those into the record. So those are in the record, but they are lawsuits. They're not facts, or they're not necessarily taken as they still have yet to be proven at this point.
Okay, thank you.
Can I clarify something from earlier, please? So Ms. Hungerford is correct that in March, with a group of teachers, I was recommended for renewal, but then after I resolved, my contract was printed and I signed it for next year, just so you have that for your record. Thank you.
So many of the points related to the policy and the speech and stuff seem to pivot on the disruption of the school. And I'm not sure who to address the question to, but I'm trying to figure out substantial disruption of the school. How is that? How are we supposed to weigh that versus somebody saying things on their own time? Because clearly our policies are slanted toward not having disruption at school. We don't want that at our schools. We want education to take place, but we have the tension between allowing people to say things under the First Amendment. How is that what is that dividing line for disruption at the school? How do we determine that? Can somebody give me some clarification?
Well, I think you need to consider it in terms of the doctrine of heckler's veto. And that doctrine basically stands for the proposition that if you engage in free speech in an appropriate way, the response that you get cannot cancel your right to engage in free speech. The heckler cannot take your right away, pry it from you. Say that now that I've complained, what you said isn't protected under the First Amendment. That's the first thing. The second thing is that Ms. Hungerford suggested that this recent case involved a student, which it did, off school time, using profanity, criticizing her coaches, criticizing the school, causing some amount of time at the school, some disruption at the school. And despite that, the court held that her speech was protected by the First Amendment. But more importantly, if you were to actually read the Manahoy case, the court reviews all of the different ways in which the First Amendment protects speech. And it casts a very wide net. It is a scholarly, historical representation of the Supreme Court's protections of free speech rights that address not only the student speech, but employee speech, employees of government speech, employees in school district speech. And the disruption in this case, I would argue, was not caused or invited by the speech protected by the First Amendment. It was caused by choices people who heard the speech made about how they would respond. People are responsible for their own responses. And the Supreme Court has said your individualized response to protected speech cannot take the right of the speaker to engage in the speech itself. But finally, the area of disruption does not have a bright line. You know, there's not, I can't tell you that it ends here and begins here. And in each of these kinds of cases, parties representing the plaintiff, parties representing the defendant, present facts and engage in argument over that issue. But I can say with confidence that the speech that they engaged in was protected.
If I may be heard on that, having recently read that decision, the court focused entirely on student speech cases, and they traced those back to Tinker and some other exceptions and findings along the way. The court was very careful to say that they were not predicting how they were going to go in the future on these student speech cases. And they admitted that they were a bit at sea, actually, about how to deal with student speech cases. But student speech has never been dealt with in the same manner as employee speech. For one thing, you know, you do have the school operating in local parentis. And so there is that factor that is standing in place of parents. So there's that factor. But I do not find that the court made any pronouncements about employee speech, and they are very different. And they did review all of the history of their student speech case in that case.
Todd?
So speaking of freedom of speech, and forgive me because of my hearing, but did you say that a staff member does not have First Amendment rights while on the job?
In the classroom.
In
they
the
do not have
classroom?
First
Can you
Amendment rights.
clarify or elaborate on that?
Yes. They're not allowed to decide what curriculum they're going to teach. They are governed by both state standards and local standards and local policies in terms of what's produced in the classroom. They don't have the ability to divert and tackle some other topic if they're teaching math, and claim that they can spend a whole classroom period teaching some other subject matter. They have a job to do, which is to teach math. And the courts have been pretty clear about the fact that the First Amendment doesn't protect students in the K through 12 range. Now, any college case I think that I would find not to be applicable. You don't have the same degree of governance. You don't have the same degree to which the State Board of Education has established curriculum and so forth. But yeah, when you're teaching, you teach based upon all of those parameters that are set for you by the state and by the school district. And you can't just deviate off into a political speech or some other particular comment. Yeah.
I don't think there's any allegation that Ms. Medart, while she was teaching, engaged in anything other than instruction. She went to school, she did her job. She did not engage in this speech when she was doing her job.
Thank you.
But the investigator did find that she engaged in some advocacy during her work time.
She engaged in some advocacy while she was at school, not performing instructional or other duties.
And is that in violation of the policy that we've been discussing?
Said
Is that in violation of the policy that we have been discussing, that advocating or participating in any of these events, even while not teaching, is a violation of the school policy? Is that correct or not correct?
I would submit that this teacher has responsibilities throughout the 8-hour day. And the teacher, where not in the classroom, has responsibilities, to supervise students, to be preparing for lessons, and so forth. So I believe that it applies throughout the 8-hour day.
Thank you.
We, of course, disagree. We don't think, as the Supreme Court said in Pickering v. Board of Education, that when you go through the schoolhouse gate, you abandon all of your rights to free speech. There are limits to the ability of the government to silence you, even when you're at work.
And the
And I
Tinker
would
case
say,
is a student case.
I would say, Chair Nelson, that we have policies that say 0, and we have policies that say breaks and after hours are accepted. I think we actually have policies on both directions.
I don't know that I necessarily have a question, but Mr. Weiser, your assertion of the Mr. Clark case here is fascinating because I sat on the board while we spent many hours discussing that. And so to bring that up here in this arena, I found interesting. I don't believe you were there for our discussions, but what I did hear was a very robust conversation over freedom of speech, and many of the board members found his views distasteful, but yet at the end of our assertion and discussion, every one of us agreed that he has the right to do and say what he likes, as is protected by the First Amendment. And so to come today and claim that the school board, at least, was complicit in squashing his right, I find fascinating because I was in that conversation. And in fact, all of the board members, to my recollection, agreed that while we may or may not agree with his points, as he was not performing and talking about those things at the school and it was not on school time, we were all in agreement that he has the freedom to do what he would like to do. And so, I mean, I hear what you're saying, and I think for at least me personally, I struggle with this freedom of speech concept because I think we all agree that we do have freedom of speech as protected by the Constitution, and this application of where that free speech is applicable and not applicable is obviously the point of contention and debate today. But to assert to the public that the school board did not honor his freedom of speech would be incorrect, sir. And
No,
so I
I'm
would
afraid
just...
I hate to contradict you, but I submitted the 10 updated policy directives that were submitted to Mr. Hackey with respect to Ryan Clark. And they sought to forbid him from engaging in speech if taken on their face, in his house of worship, speaking at the farmer's market, speaking away from school. He never did speak at school. He was
You're right.
very careful.
We agree on all
But
those things.
I wasn't part of your discussion, but I did read those directives, and I did submit them. And they were withdrawn ultimately because Mr. Hackey didn't agree to them, because one, he'd never done what he was asked not to do. But more importantly, they would have forbade him away from the school to engage in free speech. Now, maybe you haven't seen those directives. Maybe you weren't advised that those directives were being floated. You know, they were withdrawn.
Well, I know the conversation that the school board had with regards to that discussion, and I know that everyone on this panel agrees in the ability of individuals to speak their mind, and I think we all stand up for free speech. Our definition of when to apply that is, I think, the contention, but I guess we had a robust conversation, and our school board, in, I believe, unison, all agreed that we have the freedom of speech to speak as we would outside of our employment spectrum. So,
Okay, that's
So-
inconsistent
so
with
Chair-
the policy
Chair Nelson?
directives that were given to Mr. Clark
Okay.
for his consideration
I think
afterward.
I appreciate it. I wanted to at least let the public know that as you're making insinuations that those have been taken away by the school board, that was not the discussion that we had. So, Gary.
So yes, Chair Nelson, I concur with you that our board meeting was along the lines you just suggested. I did look through the court case for Ryan Clark, and there were directives from administration that said stuff. So that would be the disconnect I think you're kind of referring to between what the board's discussion was and what happened with
Sure.
Mr.
I think the
Clark.
insinuation here was that the board does not believe in free speech, and I wanted to make that statement, that that is not necessarily as you painted the picture.
I don't mean to hurt tender feelings, but I do read things. And I'm intimately familiar with Ryan Clark's situation. I did read the policy directives. I did read the lawsuit, which frankly isn't simply an assertion of non-facts. All of the facts asserted in the lawsuit are true and verifiable, and will be found to be true and verifiable as the lawsuit progresses and depositions are taken and discovery is done. You know, I don't mean to suggest that you did something that you didn't do, but it may be that you were not aware of what the administration or your representatives were doing. At the same time, you were having this robust discussion about how we need to protect the ability of our employees to speak when they're away from school.
Okay, thank you.
No, I think we're getting quite far
Yes,
away
we are.
from the topic, and I would feel that it would be a disservice to this particular teacher and also to your patrons if you were to factor in anything about that other case in your decision-making here. I have also read those directives. I don't believe there was any directive about place of worship. I think that most of those directives had to do with on the job, but frankly, Mr. Clark did not engage in anything on the job. The investigator has found that this employee didn't engage in activities on the job that are in violation of your policies, and for that reason. But I think that you have a number of other reasons in this recommendation that stand by their own in terms. I simply think we need to move on in terms of focusing on this particular case and the facts of this case.
I agree, thank you. Any further questions from the board? All right, we will conclude our pre-termination hearing. The board will proceed to act upon the recommendation, beginning with a motion from any board member, a second, and then we can have further discussion.
I move that we do not approve the superintendent's recommendation to terminate.
All right, we have a motion. So, Cliff, the motion was to not support the superintendent. So the previous one was to support the superintendent. This motion is to not support the superintendent's direction.
I don't know how to ask other than to say, is this situation different from this first situation, the other person, for various reasons? I mean, can you find one way with one of the teachers and one way with the other teacher if you think there's a difference?
Yes, you may certainly, if you feel that there's a difference, but
I'm just posing that question and see if there's any interest. If anybody else has an interest in maybe they're two different situations, the way I'm hearing it.
so we have
I'm
a,
not hearing
I would
well.
like to be heard on that because I believe that you have one significant factual difference between the two cases.
I sort of object.
Thank you.
We've had our hearing.
thank you, thank you.
I will second the motion.
There you go.
All right. So it has been moved and seconded. I'll now open it up for further discussion by the board members. Gary, Debbie,
Go ahead.
I'll defer.
I already did.
Huh?
I already did.
Okay. To those of you who were here before, I apologize. Much of this will be repeated. However, it is different. It is they are actually differently situated in terms of how the policies apply to them. As board members, we represent the public for Grants Pass School District Number 7. There are multiple issues that the public has strong interest in at our schools that are in focus today. The policy question about restrooms and locker rooms, the policy question about rights of employees, the policy question about if the district is presenting information fairly or if the district is indoctrinating children. These are important community issues. However, our issue today is for the board to determine if we approve of the superintendent's recommendation to terminate employee Katie Medart. This is a much narrower topic than what the public would like us to address today. However, we have to follow our policies and the laws of the state of Oregon. We have heard two sides of the issue from the district and the employee. In addition, we have numerous documents to give the board a complete record of what happened. From my occupation as an engineer, I have a very linear, sequential method of reviewing and solving problems. Please bear with me as I lay the foundation for my conclusions. There are some definitions that need to be understood for the following information. Email, like normal mail, has senders and receivers. People cannot be held accountable for emails that are sent to them. Specifically, any email sent to a District 7 employee that is not work-related by definition cannot be a violation of our policies because they are not responsible for emails sent to them. Assumptions and perceptions versus facts. Just like the game of Clue, where the object of the game is to declare the facts of the crime by information gathered, knowing a fact that was not disclosed by assumptions and perceptions is not the same as the fact being disclosed. Policy IIBGA-AR 98-2015, Electronic Communications System Acceptable Use Regulation, quote, students, staff, board members, volunteers, district contractors, and other members of the public may be permitted to use the district network for personal use. In addition to official district business, consistent with board policy, general use, prohibitions, guidelines, and etiquette, and other applicable provisions of this administrative regulation. Personal use of district-owned computers, including internet and email, accessed by employees should be limited to breaks and after hours. Report findings that were used by administration to find grounds for termination. Allegation number 1A, use of district facilities. The conclusion of the investigator is an error. The policy cited, GBG, is referencing a very technical point related to ORS 260.432. The investigator and the administration failed to properly apply ORS 260.432, which is related to using public resources on one side of a political campaign, such as a school bond. All other political speech is protected. Use time during a workday for political stuff. The conclusion of the investigator is correct, but not for the policy he cited. Once the investigator and the administration erroneously concluded that the political speech by Ms. Medart was a campaign, they used that repeatedly to sustain policy violations. In addition, the investigator used numerous emails to demonstrate the policy violations. Already noting that the violations are not ORS 260.432 type violations, they are still violations of not using district resources for personal use and for using time in the contract day. My review of the emails in question, and after asking if there were additional personal emails on the district network and being told there were none to add, finds that there are 7 items listed in the record, 4A through 4G. Remembering the definition about email mentioned earlier, we find these results. Item 4A occurs outside the contract day. Item 4B, during the contract day at 9:10 a.m., she typed FYI and forwarded the email, a policy violation. Item 4C occurs on a vacation day. Item 4D was not from Ms. Medart's email account. This should not be in her record. Item 4E, a received email only, no violation of policy. Item 4F, a received email only, no violation of policy. Item 4G was not from Ms. Medart's email account. This should not be in her record. When examined in detail, we find 1 policy violation. C, failed to designate the viewpoints. The conclusion of the investigator is in error. This is a quote of policy GBG 42721, staff participation in political activities. When engaged in off-duty activities on all controversial issues, employees must designate that the viewpoints they represent on the issues are personal viewpoints and are not to be interpreted as the district's official viewpoint. End quote. This quote by the investigator was the subject of debate and concern by the board when the policy was adopted. The example given during discussion was that an employee could not wear a Grants Pass High School shirt or insignia and give a video interview that might cause people to think their opinion was the district opinion. Ms. Medart was clearly not wearing any district insignia, clothing, or other identifying symbols from the district. No comment made by Ms. Medart verified the fact that she was a district employee. Only by using information outside the video and website is it possible to make the linkage between Ms. Medart and District 7. D, use social media and public websites. This allegation is a difficult one to decide. Policy GCAB 39/2021, personal electronic devices and social media staff, says employees will treat people with respect in order to prevent substantial disruption in school. The social media was respectful. The disruption to the school is real. It's not clear to me that the disruption was caused by the social media post by Ms. Medart, but actually may have been caused by social media posts by others. If that were determined to be the case, there may be cause by the district for disciplinary action against other employees and students. Because that's not the reason for this hearing, I will leave that to a later time. E, posted confidential information about a student. The conclusion of the investigator is an error. Policy GCAB 3921, personal electronic devices, social media staff. In reviewing the social media post in question, I find this statement about a student at the about 5:40 mark. I had a female student. She was on a journey of exploring what is her gender identity. She had made a request to identify as a male, and the request came forward to go by he and him and to change their name. So I was sent an email by a staff member saying this student is making this request. I let the student know that we are in support, that we will support this. It's the end of the quote. There is no identifying information here. The investigator makes much of the fact that there are people that can identify the student, but that is only because they have other information and, as in the game of Clue, can deduce who the student is, not because any confidential information is given in the social media. Allegations 2 and 3 were not sustained by the investigator or used by administration as a reason for this hearing, and I will not address them at this time. After reviewing the record, this board member finds that there are not enough serious violations of policy to terminate Ms. Medart. In addition, I find administration failed to follow policy KL. The 8 complaints by employees should have been handled at the building level. The email complaints should also have been handled at the building level. The complaint by Ms. Medart, a separate complaint, should have been handled by the board, and it was until the complaint was withdrawn. My recommendation is for the board to not uphold the recommendation for termination and to direct the administration to follow policy KL. Unfortunately, this recommendation will prolong the disruption to District 7, but is the right thing to do and hopefully will result in proportionate discipline for the employee. Lest Ms. Medart assume this is a vindication of her actions, I will point out that there were policy violations and employees need to follow the policies and directives of the district even when they conflict with their personal views. This should also be a cautionary notice to all District 7 employees to leave their political opinions at home during the workday. The children are under the direction of parents, and the district is not to indoctrinate them.
Thank you, Gary. Any further comments from the board members? Debbie?
So before us on this action item is to determine the advisability of the superintendent's recommendation for termination. And when it comes right down to it, I believe the investigator, when he says, and you know, he's got at least five different reasons why this termination should happen. And any one of them would be adequate for termination in my view. The first one used district facilities, equipment, or supplies in connection with political campaign. And Ms. Medart, by her own admission, used District 7 computers, email, school property, and Google Docs to share or communicate regarding the I Resolve campaign with colleagues, staff, and persons inside and outside of the school District 7. And he has exhibits showing this, and she agrees with this. I won't go over all the other things, and I won't go over all the other things found by the investigator that weren't brought up. The superintendent consulted with lawyers to make sure that he was interpreting this correctly and that he was right in making this determination. It was mentioned earlier this afternoon that I believed in not harming any student. I find that one of the reasons for cause of dismissal is number 5 here is posted confidential information about a student on social media and a public website. And there's proof in here of that fact. And so that is why I cannot vote in favor of the motion before us.
Thank you, Debbie. Any further comments from the board? Gary?
Well, Debbie, I find it disconcerting that essentially your position is that any information from the investigator is correct and true, even though clearly some of those items, some of those are point blank just false. So I'm a little not quite sure. You're not really saying that everything the investigator did was correct, are you?
Well, I don't think this should be a debate, so I will not respond to what I feel misconceptions from your department are.
Sure. The disruption to the school is the thing that bothers me the most. I think it would be good to review. The district had a policy AC. In 2008, that policy read, all restrooms, dressing rooms, and locker rooms will be segregated by gender at birth. The district will accommodate any individual needing other arrangements. Many of the complaints that came in were from individuals who worked for the district under that policy that is now causing substantial disruption to the district. In 2015, the district, the policy was changed to read, the district will maintain separate male and female restrooms, dressing rooms, and locker rooms. The district will accommodate any individual needing other arrangements. So with that change, a significantly higher percentage of the complaints that's causing disruption to the school, the people worked under that policy here at District 7. In 2019, that language was removed, and these kinds of changes, I should point out, are generally driven by the state. It's not because our local community necessarily wants to make that change, but they are state laws that we have to follow. So I'm having a hard time when we're transitioning to these new things that are coming at us, finding that it instantly becomes a substantial disruption to the school when actually what their speech was advocating for represents our policy back in 2008. Any response?
Thank you. Are there any other comments from the board members? Gary?
I also would like to note that the disruption that is said to have occurred at North, that 4, possibly 5 of the employees that filed those complaints are not employed at the school that's being disrupted. So to the extent that they use social media to further that disruption should merit attention from the administration.
So Gary, let me ask you a few questions about that then. So how much disruption has this caused to the district leadership in spending time away from their responsibilities to deal with the investigation and the accusations that have been placed before them?
I don't think we have policies for that. The policy relates to disruption of the school and the educational process. I mean, I am not happy to be here, but, you know, the First Amendment's called freedom of speech, but it really should be called freedom to offend.
All right. Well, you may cause offense wherever you go then, I guess. But that's not what the Constitution says. But we love Gary. We appreciate your comments. So thank you. Any other comments from the board members? All right, so the motion before the board, Cliff. So Cliff, I want to do this so that everyone understands and that you are understanding the motion that is before the board. So the motion before the board is Gary, and then seconded by Todd, is that we do not support the superintendent's recommendation to terminate. And so just to clarify, the motion, the last meeting that we had was to support the superintendent and to terminate the vice principal. So this is a motion different, in a different direction. This is to not support the superintendent.
I guess my question is, I'm trying to figure out, free speech is on my mind. And where does free speech fit into this case more so than it did in the previous case?
I think that a lot of the principles between the two cases are very similar.
I didn't hear that.
You said the principles are similar between the two cases. Oh.
I don't know, I'm trying to pick up what I'm hearing, but I haven't heard from two people over there, and I'm not looking to be a swing vote. That's not the point. The point is, if there is a difference between this hearing situation that's been outlined in detail and the first one with another person, another employee, which was outlined in detail, I want to identify that difference. What's different? If there's a difference, might it change the decision? You heard more. Pardon?
So, Cliff, the investigative report that we have for both of the cases demonstrated that they both had similar violations of policy.
Can I remind the audience that comments and conversation and disruptive incidents won't be tolerated, and so I just remind, this is a meeting in deliberation of the board, so again, we just ask for your continued listening and no comments or jeering, please.
So we will call for a roll call vote. Tanya.
I would like to ask that when I call for the roll call vote, I would like you to use the word support or do not support, so there's no confusion when I'm writing it down.
Can you repeat the motion?
Yeah, we can't,
The motion was to approve, to not approve the termination of Ms. Neal. So, is it okay for me to ask that if you say support, you're supporting her? If you do not support, you are not supporting her.
No. So I think we would ask everyone to restate the motion as you understand it, and then your vote, please, so that as you give your answer so that there's no confusion.
Policy states that we have to say yes or no. So support and not support.
Okay, so the motion on the floor is, do not, Member Richardson does not approve to terminate Ms. Neal.
I do not approve or agree with Member Richardson's motion.
But you have to say yes or no.
I approve the motion.
I can't get the answer I need, so I'm abstaining.
So Cliff, prior to in conversations with the attorneys, we're not allowed to abstain. We do need to have a vote.
Not allowed to abstain?
So if you need, I don't,
Well, okay, then I want to hear from two more people. Can I hear from two more board members if we're all expected to be involved? Or can I invite the other two to say something if they want to?
so I believe that we are in the voting process, and so the discussion has ended. Is it appropriate to let Cliff go last? I mean, I don't know how to, I'm looking at the bill. What would you recommend as far as how we proceed with this?
You're in the voting stage. I think that the order of the vote, as long as everybody has an opportunity to vote, I think the order is immaterial.
Okay, why don't we continue with the vote then, please?
Member Coleman,
Um,
Member Brownell,
No.
Member Wilkins,
Yes, I support the motion.
Member Dillagrange,
No.
There's the answer.
Member Richardson,
Yes.
Member Brown, sorry, Member Coleman,
What's the count right now? Has everybody voted but me?
yes,
Is there a tie?
yes.
I don't want to break a tie. Am I have to break a tie?
You are, that is the truth.
Can I consult with the attorney?
I think it would be appropriate if both attorneys wanted to be present. Would that be within to allow, to help Cliff? I mean,
That's a nice offer. If I could talk with Mr. Ransom privately.
That's fine, yeah.
sure.
Can I talk to him?
Now, they're going to consult privately before.
Oh, good. Okay. It seems that there's a difference. But they won't let me define the difference, and I can't define this. I can't define the difference of something. But what I need to know, can I talk to you, Vice Chair?
I don't know.
I'm stretching it.
That's what your intention is, that you need to vote no. Then you would not support the motion. I would say, so I would do turn around.
But I was okay because I didn't so here except Scott and John. I had to I got it.
Okay. All right, so Cliff, I'm going to, all right, if we could, So Cliff, I will restate the motion one more time for you, and then we will ask for your vote. So the motion from Gary, which was seconded by Todd, is that we do not support the superintendent's recommendation to fire Ms. Medart.
I guess I have to say no.
Okay, thank you. So the motion stands as 4 noes and 3 yeses. Is that correct? Correct. So the motion does not carry. So we would need another motion in the opposite direction to continue. If no further motion is made, then nothing else would happen and we would end the hearing. Do we have a motion in the opposite direction?
Go ahead. Or do you want me to?
By all means.
I move that the superintendent's recommendation for termination for Katie Medart be approved.
We have a motion. Do we have a second?
Member DeLaGrange, second.
All right, it's been moved and seconded that we support the superintendent's recommendation for termination. Any further discussion? Hearing none, Tanya, we will call. Hang on, Gary likes to slip in right at the end. Yes, Gary.
It's okay to read my statement into the record.
You have every right to read your statement in the record if you wish.
I'm sorry. I will allow you to.
Okay. Tanya, would you please give us a roll call vote?
Board Chair Nelson,
Yes.
Member Neville,
No.
Member Coleman,
Yes?
Member Brownell,
Yes?
Member Wolfett,
No.
Member DeLaGrange,
Yes.
Member Richardson.
No?
Okay, thank you. So 4 in favor, 3 against. The motion passes, and that will conclude our hearing for this evening. Thank you very much for your attendance.